Citation number 785, Protection of Civil Servants' Right to Judicial Remedy and the Shift and Leave Measures, and the Overtime Compensation for Field Firefighters. Date 2019. Issue: Is it unconstitutional that under the Civil Service Protection Act, civil servants may not further seek judicial remedies after the administrative complaint and the review of administrative complaint procedure, when their rights and interests are infringed upon by inappropriate public authority measures. Second, are the Kaohsiung City Government Fire Bureau's relevant regulations on the regulation of the 1 day on, 1 day off, shift and leave the measures, and the overtime compensation for field firefighters unconstitutional? Holding. In accordance with the principle where there is a right, there is a remedy, enshrined in Article 16 of the Constitution, a person who has a public law dispute arising from his civil service status with the agency he serves or with the personnel management authorities, and considers his rights unlawfully infringed upon or consider it necessary to assert his rights, shall be entitled to file administrative complaints and to file administrative lawsuit corresponding to the nature of the relevant measures and disputes in respect of his civil servant status. In respect of his civil servant status. So, disregard of their civil servant status, the civil servant are entitled to file administrative lawsuit, but it should be corresponded to the nature of the relevant measures and the disputes. And the entitlement is irrespective of his civil servant status. Article 77, paragraph 1 and Article 7884 of the Civil Service Protection Act, as amended and promulgated on May 28, 2003, do not preclude a civil servant from seeking judicial remedies and initiating an administrative lawsuit corresponding to the nature of the relevant measures when he considers his rights unlawfully infringed or consider it necessary to assert his rights. These provisions do not contravene Article 16 of the Constitution, guaranteeing people's right to judicial remedy. So, when he considers his rights unlawfully infringed or consider it necessary to assert his right, these provisions do not contravene Article 16 of the Constitution, guaranteeing people's right to judicial remedy. Because Article 78 and 84 and Article 77, paragraph 1 do not preclude a civil servant from seeking judicial remedies and initiating an administrative lawsuit. So therefore, these provisions do not contravene Article 16 of the Constitution, guaranteeing people's right to judicial remedy. It means that J1 interpretation number 785 interpreted the disputed provisions as constitutional, but the interpretation, the meaning of the interpretation has been slightly changed to have a meaning that Article 77, paragraph 1, Article 78, and Article 84 of the Civil Service Protection Act do not preclude civil servants from seeking judicial remedies and initiating administrative lawsuit corresponding to the nature of the relevant measures when he considers his rights unlawfully infringed or consider it necessary to assert his rights. So, when the law does not specify a right, that kind of right exists based on the Constitution, based on the Article 16 of the Constitution, because the Article 16 of the Constitution guarantee people's right to judicial remedy. So, even though Article 77, Paragraph 1, Article 78, Article 84 of the Civil Service Protection Act does not specifically specify a right to initiate administrative lawsuit, even though it does not specify a right to file a lawsuit. The interpretation is that it does not preclude civil servants from seeking judicial remedy and initiating an administrative lawsuit corresponding to the nature of the relevant measures when he considers his rights unlawfully infringed or consider it necessary to assert his rights. Because these rights are guaranteed by Article 16 of the Constitution, which guarantee people's right to judicial remedy. Okay, Article 11, Paragraph 2 of the Civil Service Act prescribes that the civil servants are entitled to 2 days of regular leave every week. Agencies with special work nature may alternatively adopt rotating shifts and leave or other flexible measures.